Welcome to the final installation of webinars regarding Utah's Least Restrictive Behavior Interventions Technical Assistance Manual. The Utah Parent Center is pleased to bring you this in conjunction with a grant from the Interagency Outreach Training Initiative from Utah State University Center for People with Disabilities. Today, our presenters are Carol Anderson, the Utah State Board of Education Specialist on Behavior and School Discipline, and Natay Dearden, the USBE Specialist on Dispute Resolution. They will be discussing discipline procedures under the Individuals with Disability Education Act, also known as IDEA. During this live webinar, you may type in your questions and they will respond as they are able. This webinar will also be posted on the Utah Parent Center YouTube channel and on our website. If you have questions about this subject or other disability-related issues, please feel free to contact us at 1-800-468-1160. Thank you for joining us.
Thank you for your participation today. It is our pleasure to be with all of you here. Hold on, a little technical problem here. There we go. Okay, our presentation topics. First, as Linda said, we will be discussing information on the Individuals with Disability Education Act, IDEA, which includes specific discipline procedures schools must follow for students who are receiving special education services. This webinar will discuss frequently asked questions. We get a lot of questions at the USDB, particularly around IDEA discipline procedures. Some of these questions will include, can a school suspend or expel a student with a disability for violating a code of conduct? What counts as a disciplinary remover? What is a manifestation determination meeting, and when is the school required to hold one? What is a school's responsibility to provide special education services during a long-term disciplinary removal? So let's go ahead and get started. The first question we want to address today is, can a school suspend or expel a student with a disability for violating a code of student conduct? I think the important thing to remember here as parents is know your school's discipline and conduct policy. Policies must be aligned with state and federal requirements, posted and reviewed, and this is where I encourage you as parents to go onto your children's websites, their school websites, and look for their school discipline or code of conduct policy. They are required by state board rule that these are posted, and I encourage you to review those. A big thing to remember is that these codes of conduct need to be applied fairly and consistently to all students, and that they be grounded in evidence-based practices. So let's talk about the alignment of IDEA and schools' code of conduct. First, review the code of conduct to determine whether consequences is aligned with your school policy. Ensure code of conduct was applied to a student with a disability in the same manner in which it would be for a non-disabled student. A way to think of this, and we know nationally that our students with disabilities get suspended or expelled at higher rates than their non-disabled peers. So this IDEA protection is that if a student that has a disability is to get disciplined, it needs to be for the same infractions that a non-disabled student would be disciplined for. So that's why I encourage you as parents to know these codes of conduct so you can determine if your child is facing disciplinary actions. Is it consistent across the board? Understand purpose for the limited amounts of suspensions. So you might hear a lot about school suspensions, the good and the bad of it. But I think these are some key points to remember. That suspension should really be used as a planning and addressing safety factors. I have the opportunity to train a lot of educators in the state of Utah. And I always talk with them about the use of suspensions and wanting to make sure we're using it at the right time and it's not our only mechanism when we're disciplining students. So there are times when suspension is used, and really knowing that in doing that, it might give the school an opportunity to sit down and do some planning and address safety concerns. Because the majority of times students are suspended when there's been an injury or a situation with bullying, where there is students that maybe have experienced some safety concerns. So suspensions can be used as a reset to kind of say, okay, let's everybody regroup, save face here, and see what we can do. A lot of time, suspensions need to be used for a restitution for a victim or a victim's family, meaning that somebody has been hurt or injured. And typically then a victim or the victim's family wants to know that something has occurred. That it can be really used for a consequence for harmful actions, a student-on-student harmful action, or a student to a teacher harmful action. And that we really want to also make the point that consequences need to happen that need to teach and change behavior and not just be punitive. And this is where we share a lot of information with educators that, yes, there might need to be a suspension, but what are the other consequences that need to teach and change behavior? Because the research tells us that suspensions do not have a proactive effect on changing student behavior in the long run.
Okay, so one of the things we wanted to address is a lot of folks are familiar with certain types of disciplinary removals, but we have information that is grounded in case law and from the U.S. Department of Education that lets us know that it's not just plain suspension that counts as a removal.
Can you see that?
We're having somebody who cannot hear. We want to make sure other folks can hear. So we're going to
Have to check in, baby.
Yeah. I can't see where the chat is, though.
Chat right there.
Okay. So we're going to keep it moving, and we'll work on sound because it looks like one of our participants cannot hear. So one of the questions we wanted to cover is what actually counts as a disciplinary removal. And what many of us are familiar with is short and long-term disciplinary removals and what the difference are between those. So on the left side of the screen, we have what a short-term disciplinary removal is, which that's something that is typically less than 10 consecutive school days. So it may be 1 day, it may be 3 or 4 days. The most common example is a student being suspended for several days in the home. That is contrasted against a long-term disciplinary removal, which we're going to talk about more later on in the webinar, which is a removal that exceeds 10 school days, typically in the form of a removal to a different setting, which in special ed law is called an interim alternative education setting, or expulsion. So expulsion is the act of expelling, and we're going to talk about how it's really not possible to expel a student with a disability because they're always still entitled to receive services past a certain point of removal. But we're going to get there. So one of the questions we get a lot, I think the Parent Center gets this question a lot too, is do in-school suspensions count as a removal? And what the federal guidance has given us is that an in-school suspension would not count as a day of suspension or removal as long as the student has the opportunity to appropriately participate in the general ed curriculum, continue to receive the services specified on the student's IEP, and continue to participate with non-disabled peers to the extent the student would have in his or her current placement. Now, we share that with you because it's my understanding in some of the calls that I get from parents that that's not always what is happening in school suspension. A lot of times students are more isolated. They may or may not be working on the general curriculum. They may or may not be receiving special Education Services as written on their IEP. So if they are, then those things would not count as a suspension, but otherwise that would be a suspension or a removal as well.
Okay, I think we stopped sharing.
Did we stop sharing?
No, you're sharing, but you're sharing all of the menus.
1 second, we're just having a little, there we go.
Okay. And as I put at the bottom of the page, sometimes we have students removed for portions of the day, and it really comes down to a case-by-case basis, but portions of a school day that a child has been suspended may be considered as a removal, especially when we're looking to see if there's a pattern of removals. So another question we get a lot is, what about a student being suspended from the bus or student transportation? Sometimes that happens, will happen, and we'll get a call and we'll wonder if that counts or not as well. And what the law says about that is if transportation is a related service in a student's IEP, then that would count as a day of suspension under the IDEA. However, if a student is not entitled to transportation because it's not on their IEP, then it's kind of that same responsibility that any student and any parent would have to get the student to school. And so that would not count as a suspension for the student. I think one thing to keep in mind that sometimes schools and IEP teams need to consider when they're planning is the behavior supports and accommodations a student may need on the school bus. So when we do see a suspension, kind of like Carol talked about earlier, that we're proactive and we look at other ways of supporting the student and not just let it kind of go on, because we definitely don't want students to miss an opportunity to attend school because of challenges on the bus. So this is where we're getting into guidance from the Department of Education that goes beyond just a formal suspension that you're probably familiar with. Several years ago, the Department of Education issued a guidance document to schools, and it included information about paying attention to exclusionary disciplinary measures. And that means measures that schools take that exclude students from the educational environment. And so what the Department of Ed said is schools should take care when implementing exclusionary disciplinary measures that significantly interfere with a child's instruction and participation in other school activities. So I bolded that because that's really what we want to pay attention to, is how removal is impacting a student's ability to get instruction and be in other school activities. And so the Department of Ed acknowledged that, just kind of like we talked about earlier with suspension, there are some things that limit privileges, such as the use of study carrels or a timeout, other restrictions. And if a school uses those consistent with the student's right to their free appropriate public education, then that's okay, and a school can use those things. However, in this third bullet, the Department of Ed cautioned that when school staff are not properly trained in the appropriate use of these practices, the improper use of these measures could rise to the level of a removal. And so we wanted to give you some examples of what those might look like and to keep an eye out for them. So you'll notice the title, I pointed out could. These don't always indicate a removal, but if there's a pattern of them, they certainly could. And so that's when we look to see whether a student is experiencing a pattern of office referrals. And sometimes that may mean they are sent to the office and spend a significant amount of time in the office for those referrals. Extended time excluded from instruction. Again, we know that timeout can be an appropriate reset for a student, but if there's a pattern of using it such that a student's excluded from instruction a lot of times, that could be a removal. That also goes to extended restrictions and privileges. Carol and I get a lot of calls about this next one, where schools send a student out of school on administrative leave or a day off. They'll often call the parent and ask the parent to come and bring the student home. Some schools resort to shortened school days just by sending the student home at a certain time every day. And occasionally we'll see a school removing a student and telling parent the student cannot return without a risk assessment or psychological evaluation. So those are inappropriate removals in many cases, and schools should be really careful about using those and also counting and documenting them. So I included this quote. I'm an attorney, and what we know with a lot of law, we joke at the USBE that the answer to a lot of our questions are it depends. And so I want you to know that determining whether an in-school suspension or a bus suspension or some of these other removals we talk about, whether those count as a day of suspension really depends on the unique circumstances of each case. And so I think it's definitely important as a parent to keep track. If you are seeing any of those things that we just talked about, document those and keep track of them. And if you begin to see a pattern of removals that you feel is excluding your student from instruction and participation in the school day, that is something to raise with the team and to address in a proactive way before we get to the direction we're going in the rest of this webinar, which is what happens when we have these disciplinary removals. So Carol's going to talk to us a little bit about safe school violations and special circumstances.
Great. So the question that we get a lot is, what is the difference between a safe school violation and a special circumstance under IDEA? So I think it's very important as a parent to know these differences. So if your child or your student does face a safe school violation, you'll have the knowledge to know if the safe school violation included a special circumstance. So let's look at this information. First, let's just kind of talk about what a special circumstance is. School personnel may remove a student to an interim alternative education setting or an IAES for not more than 45 days without regard to whether the behavior is determined to be a manifestation of the student's disability if. So they may do this if these three special circumstances, one of them occurred. So the first one is carries or possesses a weapon at school, on school premises, or at a school function under the jurisdiction of an LEA. So really thinking about what is that weapon, and it being part of a special circumstance. The next is knowingly possesses or uses illegal drugs or sells or solicits the sales of a controlled substance while at the same criteria as above, while at school, on school premises, or during a school function under that LEA. So you have their weapons, you have the illegal drugs, and the next one that we get a lot of questions on is really that has inflicted seriously bodily injury upon another person while at school, school premises, or at an school activity. Now, because of our time frame today, we're not going to go into a lengthy definition of what seriously bodily injury is, but by all means, if you have more questions on that, please either look at the Utah State Board of Education's website under special education, and you can find a good definition of that in the IDEA state rules, or there's also information on a definition of that in the Least Restrictive Interventions Technical Assistance Manual, LRBI.
So we wanted to talk about what a school's responsibility to provide special education services during a long-term disciplinary removal is. So what we've talked about so far is this piece of that students are removed, and we talked about short-term and long-term. So now when we're in a long-term removal, and this is a protection that's available to students with disabilities that is not typically available to students who do not have a disability and don't have an IEP. So what the special ed rules, both federal and state, talk about is after a student has been removed from his or her current placement for 10 school days in the same school year, during any subsequent days of removal, the school must provide services to the extent required. And so, again, as a parent, it's really important to keep track of those removals, because what we're wanting to ensure is that a student does not go past 10 days without receiving school services. And we're going to talk a little bit about what those services should look like. For a student where a removal like this looks like a removal from their current placement, this is what the law further talks about they need to receive. And so I've bolded out some important pieces to be aware of. One of them is these services should enable the student to continue to participate in the general education curriculum, even though the law acknowledges the students in another setting, and to progress toward meeting the student's IEP goals. It also specifically calls out that a student needs a functional behavior assessment as appropriate, and that would include behavior intervention services and modifications that are designed to address the student's behavior so that that violation that occurred that led to the removals does not occur again. The law acknowledges that these services can be provided in a different setting, but the law talks about that if this removal the student experienced was a change in placement, that the student's IEP team determines the appropriate services. So one thing that we see happen occasionally is kind of an incorrect application here of school district and charter school home and hospital policies. And sometimes when a student's been removed for disciplinary reasons, what a school tells a parent is, okay, student's going to get 2 hours of services a week, and we'll send someone over to check on them and whatnot. And a lot of reliance on packets or worksheets and different things. And so one of the things that we wanted you as parents to be aware of is that is probably not in keeping with this slide that we're looking at right here and the rule that's listed on this slide. And that we know that the instruction the student needs to receive needs to be aligned with their grade level curriculum. They need to be making progress toward those IEP goals, and many of them need to be receiving behavior intervention services. And so if those things are not happening, I would really urge you to go to your IEP team and to schedule a meeting and to make sure that it's the team that's determining the services, not you just being told by the school what the student will receive. And I think that's an important consideration when you look in case law. Many judges have said that doesn't necessarily mean the student will get the full amount of minutes and hours that they did when they were at school, because we know we need to make some adjustments there as to what's appropriate. But it also doesn't mean that it's a set number that's limited to like 2 hours for every single student in this situation. So now we're going to talk a little bit about what a manifestation determination meeting is and when a school is required to hold one. And these are honestly some of the trickiest sections of the special ed rules. And so we're going to do our best to explain these clearly. But again, as we noted at the beginning of the webinar, if you've got further questions, please reach out to us. So first of all, the idea is that what triggers a manifestation determination is a change of placement due to disciplinary removal. So I'm going to back us up and think about every year when your student has an IEP meeting. One of the things we talk about in the IEP meeting is what your student's placement is. And it will often be in the gen ed setting or the special ed setting, depending on where they receive their services and how many services and supports that student needs. It's an individualized decision. But what the law says is in the context of removing students for discipline purposes, at a certain point, that student's placement has changed because we've removed them so many times. And that's when these protections can kick in. And so we call that a change of placement for disciplinary reasons or removals. And one of those times that the law says this happens is if a student is removed for more than 10 consecutive school days. So that means 10 days in a row a student has been removed. That means their placement has changed because of a disciplinary removal. The law also looks at whether the student has been subjected to a series of removals that constitute a pattern. And so what a lot of schools kind of pay attention to are these sub-bullets below. One of those could be that we have a student who's removed more than 10 days throughout the school year. So they may be removed for 2 days in September and maybe 3 days in October and then 4 in November. The school is required to track these, but I think it's great as a parent to keep track of them as well. And when you're seeing them kind of happening a few days at a time, we look at these other bullets as well to see if the behavior that led to these removals is similar and it could constitute a pattern. And we also look at how close they occurred to each other, the total amount of time the student was removed, and things like that. And so that is a little bit different determination than just the clear-cut 10 days in a row, but most of our kids we're going to see removed for a series of removals that constitutes a pattern. And so when these conditions happen, that is what is going to trigger a manifestation determination review. And so what the law says is on the date that the school decides to make that removal that becomes the placement, whether that's the day where the school issues a 10-day of consecutive in a row removal, or whether we were at 8 or 9 and the school suspended your student for 2 more days and that's going to tip us over the 10-day mark, the school needs to provide you with notice of that decision and provide you with a copy of your procedural safeguards notice. And then they also need to schedule this meeting. And what the law says is that this manifestation determination includes the parent or the adult student, school folks, and relevant IEP team members who should participate.
So during the manifestation and determination review meeting, part that's in the law is the information that should be considered in determining was the code of conduct violation in direct relationship to the student's disability. And as doing that, we really need to look at what information to base our decisions on. Unfortunately, too often, I think this is a step that's missed when during an MDR meeting is saying, okay, what is the relevant information in the student's file that needs to be looked at and considered during this meeting? So I think one being, of course, the student's IEP. Looking at the student's IEP and looking at what goals and services are written into the IEP, and does that need to be changed to address the behavior that is interfering with that student's learning. Really consider any teacher observations. Teachers are great observers in their classrooms and have a wealth of knowledge when it comes to what is occurring within the classroom and what is the student doing. And of course, any relevant information provided by the parents. What information do you bring to the table? Because you really do know your student the best. And your opinion should really count in these meetings. And you have relevant information that should be brought to these meetings. Sometimes we get the question about school requesting information from the parent that might be protected under HIPAA, under your medical rights. If your child is seeing an outside therapist, or has received services through a medical provider, you are not bound to bring those unless that is your choice. So just know that if a school is requesting those, you still have the right as the parent to share those or decide not to share those. Other relevant information in the student's files would be evaluation data. And I think this is one that's missed often, is to think about, we do look at our evaluation data when we're either doing an initial evaluation of the student into special education or at the 3 years when the student needs to be reevaluated. But I think it's important to think about what critical information is there when it comes to the evaluation data, and that really being kind of the performance or the ability of the student. What is like their processing speed? What is their comprehension of situations? And what is their social and emotional abilities when it comes to these situations? Also really looking at what is the discipline history. Through state board rule, schools are required to keep disciplinary actions in the student information system or an SIS system. So if you have to do a manifest determination review meeting and the school has not brought that data to the table, I think that would be really important to happen. And that's where you're going to also find the details of the incidents or the number of incidences that have triggered looking at doing a manifestation of determination. During that review, there's two main questions that the team really needs to answer. And I think as you look at these questions, you'll see why it's relevant to have that information when determining and answering these two questions. The first was the student's conduct caused by, or did it have a direct and substantial relationship to the student's disability? Now, with that said, too often we get phone calls that will say, well, the student was qualified emotionally disturbed, so it must be an automatic related to their disability. Now, remember, a classification is not an automatic. It is really up to the team at this point to answer these questions on a case-by-case basis based on that information that has been brought to the table. The next question is, was the conduct the direct result of an LEA's failure to implement the IEP? That's why it's important to look at the IEP and determine what is in that. Was it implemented? And I think the best way to say, has an IEP been implemented, is what performance data or what data has been collected on that IEP. For each goal, is there progress or is there lack of progress? And really saying, that's when you can say, has an IEP been implemented, is because there's data showing that level of implementation and performance on the student's end. Another great resource in the LRBI, because as Nate said earlier, when we get into ID discipline procedures and violations of code of conduct, it can be really tricky to understand, and it's not always so black and white. So when we put LRBI together, and there's a whole section in LRBI that goes through school discipline procedures, we wanted to put together a flow chart that would be easy for people to use. So there's one way to start this flow chart and one way out of it. You just go from the top down to the bottom, and you work through the boxes and the arrows and answer the questions. So if removal is more than 10 consecutive days or 10 consecutive days in a school year, that is a pattern, then is a change of placement. And then you'll see some additional text there that will help you walk through that, as Nate was talking about. At that 10-day mark, if you follow hours down, you'll see that's where it talks about you need to do your manifestation determination. It gives you more information. Now here's where we get other questions. So during the manifestation determination review meeting, if the answer is no, the removal was not a direct relationship to the student's disability, the student is not a manifestation of their disability, any relevant disciplinary procedures apply to students without disabilities. So this is when we said it's important to know your school's code of conduct, so you'll know what disciplinary actions are applied to non-disabled students, because at this point they can be applied to your student with a disability. Then let's look at the other side, the green box. So if either answer is yes to one of those manifestation questions, the student's conduct is a manifestation of the disability, the team needs to conduct a functional behavioral assessment and implement a behavior intervention plan if there's not already one in existence. If there's already one in the student's file, then it needs to be modified, or it needs to address the behavior that got the student removed or for the 10 school days and while you're doing the MDR meeting. So just wanted you to know that that resource is in LRBI. And I would encourage you, if you're doing a manifestation determination meeting, actually printing this off. It is available on the Utah State Board of Education website, and taking it with you to the meeting, because it certainly can help you as you're going through this process, which is not always an easy thing to do as a parent.
So one thing that Carol and I have learned and seen a lot, and I borrowed this information from an attorney who works in the field with this, is that a lot of times what parents have frustration about, or what the dispute is about, is going back to to the original offense and also going back to the school's disciplinary code and procedures just generally. And so sometimes that's because there's questions about whether or not your student actually committed the offense and the evidence or lack of evidence that the school is seeming to provide. Or maybe you know that the student committed the offense but felt like the penalty was too harsh or the penalty wasn't applied in an equitable way. And we just wanted to point out that those are not questions that will be reviewed in a manifestation determination process, because those aren't really under the purview of the IEP team. Those issues are the purview of school administrators, and there are also due process procedures connected with those. And so as you look in your school's discipline code and policy, that will be made clear about how you could appeal that. And what we encourage is, if that's where your questions are and concerns are, to use that due process proceeding first to come to clarity as a school and as a family about those issues. Because if you get to the manifestation determination, these things will not be discussed in there. We did have one question along the way that I wanted to answer. We had a question someone asked about partial days of removal and how to count those. And honestly, there's not a black and white answer of how to count those. The Department of Ed acknowledges that partial days that should count as removal. I think some schools tend to count those as just a full day. Others may not. And technically, they could probably count like a half day or get down to hours. As a parent, I would just urge you to keep careful records and to push the school to do that as well. Because again, I would say as a parent, if a couple of small partial removals happen during the school year, and I understood the circumstances surrounding that, maybe I'm okay to not push for those to be counted. But unfortunately, what we see in some tricky situations is an ongoing pattern of partial removals, whether it was an early day out, a call home to mom, or going to the office a lot of times. And as a parent, I would advocate and push the school to understand that those count as removals, and whether we're counting them as hours or days, we need to be vigilant about the times our students are not receiving instruction related to behavior that is potentially caused by their disability. So we have this question, what if you do disagree with the school's disciplinary decision? And we kind of talked about that a little bit, with that you have due process options with just the general piece. But what if you disagree with the manifestation determination? Those two questions Carol just reviewed. That as the team has the meeting and works through that process, you're in disagreement with what the team came to. And so I wanted to give you just a general slide that hits on the various dispute resolution procedures available to parents. And those are outlined in your procedural safeguards notice that you receive at every IEP meeting. And then, as we talked about, upon your student receiving a disciplinary change of placement. And I've actually hyperlinked this image. So if you click on it, it should take you to this page, but we have a link at the end of the presentation as well. But you can see those forms that you can use to request different processes, such as mediation. You could file a state complaint if you felt like the school is not following the IDEA procedures. But what often comes into play in disciplinary situations is due process. And that's because the law allows something called an expedited due process hearing in situations regarding a manifestation determination. And it's my sense that the law allows this because disciplinary removals have a big impact on a student. And so typically a due process hearing can stretch out, that process can stretch out to 75 days if the parties really go to the full length of time for different things. But for an expedited due process, that time frame is cut down to 20 days. And it is only available in the context of a parent who is disagreeing about a disciplinary placement decision. And so let's say you were in a manifestation determination scenario and you felt that either the team did not follow the processes correctly or you are in disagreement about their determination as to whether or not your student's behavior that led to the removal was a manifestation of their disability, you can request an expedited due process hearing, and it happens quickly. And what I'd encourage you to do is if you have questions or need assistance with that, you can certainly call the Parent Center, can reach out to the Disability Law Center. You can give us a call if you have questions about how to access that form and what the process looks like. But it is described in your procedural safeguards notice. The other thing I wanted to touch briefly on that I don't think I put a slide in is if you feel that generally speaking, the school's disciplinary procedures have been applied in a discriminatory manner, you may file a complaint with the Office for Civil Rights. And that complaint can be filed online or you can call them. Our regional office is in Denver, and we'd be happy to share that information with you. But I think that's something that comes into play if you feel that, you know, as we talked about in the very beginning of the webinar, the school's not following the discipline code the same for each student, and you fear that there may be some discrimination going on. So one of the other questions that happens sometimes is, what if your student doesn't have an IEP yet? Let's say you're a parent who knows your student has had some challenges and you may or may not know your student has a disability, and you're curious about whether or not these protections apply to your student who does not have an IEP. And so I wanted to fold in some sections of the rule that talk about that. So these protections can apply to a student who does not yet have an IEP if the school had knowledge that the student was a student with a disability. That means kind of under the law, under the IDA, before the behavior that precipitated the disciplinary action occurred. So that means if the school knew your student had a disability and may have qualified for an IEP before the behavior incident happened, then these protections could apply. And the law gives some examples of how the school would have known that. And so one of those ways is if you as a parent express concern that your student was in need of special education and related services in writing to the school personnel or student's teacher. And that's a little different than just a regular special ed referral that we know the law says does not have to be made in writing. But I believe it specifies in writing this time because when we're dealing with disciplinary things, we need some hard documentation. And I know that a lot of the Parent Center advocates, and we will too, anytime you're making a referral to a school, we encourage you to do it in writing just so you have that documentation yourself. If you requested an evaluation from the school, that could also count as the school having knowledge. But this third bullet's important to pay attention to, and you may or may not know if this happened. This says the student's teacher or other school personnel expressed specific concerns about a pattern of behavior demonstrated by the student directly to the school special ed director or other supervisory personnel. And so I think when we're in this kind of area where you suspect the school knew, that's when getting the student's records, kind of like Carol said, reviewing any progress reports, any notes, any documentation we've talked about today, whether we could say that means the school had information that the student may have had a disability. Now, I wanted to talk about when the school is not counted as having knowledge because that happens sometimes too. So let's say the school had a suspicion and they asked you as a parent if they could evaluate your student and you said no for whatever reason. If that has occurred, then these disciplinary protections would not come to play because the school attempted to evaluate and you refused that. The second bullet in the law is whether, the school offered these services and you refuse them as a parent. And in part, that's because we respect parent wishes, and so we can't have it both ways. If we don't want any services, we also won't be entitled to the protections that come. Lastly, if your student was evaluated and the team had previously determined that they were not eligible for services. And I think that's another area of dispute resolution, and sometimes that will come into play with all of this. And again, that's where you may utilize a state complaint or a due process hearing if you felt like there was some disagreement about that. If the school did not know that your student may be an IDA qualifying student, then just as Carol mentioned before, the student would be subjected to the discipline applied to students without disabilities who engaged in comparable behavior. So the law also says, what if you're in the midst of this removal and you as a parent want to request a special ed evaluation? And we see that happen sometimes because sometimes when we get to this point, we recognize there's maybe some issues we weren't aware of or weren't dealing with, and we need to work together as a team to determine if a student would qualify for services. And so what the law says is if you request an evaluation during this removal, we need to do it in an expedited or quicker manner than the 45 school days for an initial, or just kind of a reasonable amount of time. We want them to do it quickly. Until that evaluation is completed, the student remains in the placement the school determined. So that could be suspension or expulsion. But if through that process we finish the evaluation, we meet as a team and determine that the student is a student with a disability, then that student would begin receiving special ed and related services in their removal. And so in my mind, that kind of gets rid of an expulsion, because to me an expulsion means no services. And what we know is students with disabilities past 10 days of removal are entitled to services from the charter or the school district. So I'm going to turn the time over to Carol to talk about some best practices.
Great. So one of the questions we get is, what are some disciplinary best practices schools and families should utilize when working with students with disabilities? I'm going to kind of expand this and say not just with students with disabilities, but I would say all students within the state of Utah. What are some of those best practices and requirements that schools should be doing when working with students on their behavior supports? So I think first is looking at those alternative practices to punitive discipline, so those exclusionary discipline measures that remove students from instructional time or from instructional settings. We want to say, okay, what are some of those alternatives, and really helping schools have those within the state of Utah. The first one would be PBIS, thinking about what is positive behavior supports and interventions, and what does this provide for us. So per state board rule R277609, school districts and charter schools are required to have the 4 basic components of PBIS in a school-wide system. The next is to think, what are those PBIS, those positive behavior supports and interventions, that are classroom management strategies, things that are evidence-based. And there's a long list of these found in the LRBI. There's even a really good classroom management checklist in the appendix of LRBI, because I'm sure as a parent you have spent a little time in your student's classroom. I would not recommend you carry this in and do it while you're in the classroom, but by all means read through it and be familiar with what are some of those PBIS classroom management strategies, and can you see them in your children's and students' settings that they are educated in. The next one is to think, what are some of those PBI systems to help guide adult behaviors? So I keep using the word system, so let's kind of spend a minute and explain that. What we say system is like a framework. So PBIS is a framework to guide positive behaviors and also guide the adults on what behaviors they should exhibit and practice with students for the best outcomes. Then the next part of PBIS is really, what is the data to guide decision making? So looking at data is always the best way to match a student need to an intervention. So what are those PBIS data systems that are within your children's schools, so you know what their behavior is looking like in the classrooms and in the school common areas? So a lot of that data is referred to as office disciplinary referrals. So if your student is sent out of the classroom, that should be documented in the student information system, and you should have knowledge of how often that's occurring. The next practice to really think about, and maybe you've started hearing about, is what is called restorative practices. And restorative practices, or PR, is a range of promising practices that create and repair relationships to engage and re-engage students. So a way to think about this is if one student has hurt the feelings or bullied or physically harmed another student, what are some of those practices that can take place that can help repair relationships and re-engage the students in a positive way? So at the State Board of Education, we've really been looking at and really having a lot of work groups around establishing good school cultures. And what does a good school culture mean? And what aspects or practices should be considered when establishing a good school culture? We want all students to go to school and make sure they feel safe and secure and supported. Now, with that said, we have to say, what are those practices we need to consider as educators? So first being really, what are our trauma-informed and sensitive practices? Unfortunately, some children will experience what is referred to as adverse childhood experiences. A lot of research has been done around the ACEs study, or ACEs, meaning has a child experience abuse, neglect, household dysfunction. I'd even add to this list and say a death of a family member, an illness in their home. Even a divorce can be considered something that can have an adverse effect on a child. So knowing that kids come to school every day may be facing some of these, that educators are sensitive to that they understand the impact that these ACEs have and how to recognize them with students and how to help students. Then the next is what we just spoke about, the restorative practices, that we really want to maintain student dignity when we're dealing with behavioral concerns on both sides, that of the student that maybe has harmed another student and the student that also maybe has felt bullied. That we maintain dignity, that we avoid shames as a method of management. And I think really this being back to the punitive measures of exclusionary practices, or calling out a student, or getting with the student and making them feel shame or feeling bad for misbehaving. We know that not students don't purposely misbehave, that their behavior really is communication and what is it telling us to do. So really saying, what is the management and what can we do to restore some of those relationships? The next is really just looking at how do we facilitate positive relationships. If you've ever been in a situation or a workplace or had to go somewhere where you did not feel like people respected you or had positive relationships with you, that's not where you wanted to be. And by all means, we want school cultures where students want to be. And students want to be where they feel positive relationships with students and staff. I spend a lot of time training staffs on the good outcomes of having positive relationships with students and how important that is. The next thing we really want to think about when we're building school cultures is what is culturally responsive, that we need to be aware of biases, that how do we interact with staff and how does staff interact with students, and what are those biases that we need to be aware of. I couldn't help but just really put in this next one, that student voice and storytelling is so important, that the students have a voice, and it's important to sit down and hear their thoughts and their perspectives when dealing with disciplinary measures and hearing what the story was behind that. I think that really helps the students feel like as adults we do care about them, and that it is important to hear from their perspective what is occurring within the school, that there needs to be shared decision making when it comes to our responses. And then the next that we have talked about is database decision making. What is the discipline data that we are looking at to help create a school culture that is supportive and caring? And then evaluation of intervention and practices. So are the interventions and practices that we're using within our school cultures appropriate for the students? And are we getting the outcomes that we have anticipated by doing those good practices within school settings? So let's just kind of talk about the goals of restorative justice or restorative practices in schools. There's been some recent changes to juvenile justice code within the state of Utah. And in that code, it has written in that schools need to consider restorative practices in schools. Restorative practices include climates that are responsive and not punitive. We want to see through these restorative practices a decrease in suspensions, expulsions, and disciplinary removals by still holding youth accountable for their actions through preparing harm and making amends. So always holding students accountable before their behavior, but connected to us in the school system. Are we teaching? Are we understanding? Are we using data to make sure we're getting the best restorative practices for all those involved? Understanding the impact of behavior on others. This is a great skill for students to learn. And as we teach academics, we need to be as focused on teaching our behavior expectations and understanding that your behavior could have a negative impact on others is a really great skill for students to learn. And suspending students or doing exclusionary practices, it's hard to do this. So that how do we teach students to really know that their behavior could have an impact on others, and if they have harmed others, that they need to apologize and make amends and sit down and work on healthy relationships. Another thing that's so important around restorative practice is in parent engagement, that you are in part of the students, the teachers, the school staff, and the administrators, that when we sit down and reduce restorative practices, that you're at the table understanding whether your child is the perpetrator that maybe has hurt somebody or your child has been the victim, that you're willing to sit down as a parent and hear both sides and come to a workable solution. The other great thing about restorative practices is it really avoids labeling the students. I don't think any student purposely is bad, but their behavior is communicating something to us. But unfortunately, sometimes we'll start labeling students as being bad or ungovernable or habitually disruptive, that we need to look at how do we teach more appropriately and restore relationships and restore school culture and climate to a positive instead of just using student labels. And by all means, we want to always uplift students and build our interventions on their strengths and know that all students have strengths. And it's important that they feel those and we're using those as a benefit as we move forward.
Okay, so we just wanted to include some of the resources that we've referred to throughout this presentation. And so what we started with was the procedural safeguards notice that you should have a copy of, but there's links to it online. Next is the manual, the LRBI manual that Carol's referred to, where that helpful flow chart came from, and there's plenty of other flow charts and information there that you may find helpful. A lot of the information in this webinar came from our state special ed rules, and so I included a link to that, including the section that you could go to review that. But I also included state administrative rules and state code, where a lot of our general education disciplinary practices come from. And so when we're talking about appealing just the general decision of the school and the removal, that's where you would go to learn more about that. And then the information we shared about removals, and from the Department of Ed, it came from this Dear Colleague letter that was released about 2 years ago, and I included the link for that. Now I think we're going to open this up. We're going to give you our contact information, but we have time for questions now, and there may have been some questions asked, so we're going to check and see real quick.
Or if you have questions at this point,
Now's a good
please do
time.
not hesitate to ask them. We're happy to answer any questions you might have.
Sorry, I'm scrolling. I'm still scrolling.
We just want to make sure we haven't missed any questions.
Okay, Heather says she has a question. So Heather, feel free to type something in and we'll see what you're asking. Where can I find ideas for classroom management systems?
I think the first place you'd want to start looking at is in the LRBI. There's a whole section on effective classroom management, and then also the checklist in the back of LRBI on page 122 to 124 outlines and goes through research-based effective classroom management interventions.
Great question. Anyone else have questions? Please enter them now. Okay, well, I think we can wrap this up. I'm surprised we aren't getting questions, but I know it's a busy time of day. You're probably getting ready to get kids from school or get dinner on the table. So we'll wrap this up, but we have our contact information, and Carol and I, we field a lot of calls about this. As you know, the Parent Center, they do too. So we're happy to have you reach out and speak with us, especially because we know a lot of things are so situational specific and school specific. So thanks for your participation today. We really appreciate it. And we look forward to seeing or talking with you later.
Thank you.
Thank you both for helping us. It was great information. I know there's a lot to it. As you have questions, feel free to contact them or us at the Utah Parent Center. This information will be posted online and also on our YouTube channel and on our website. So watch for a notice on that, and also feel free to contact us anytime. Thank you for coming.